the chairman, and I rise in strong opposition to the amendment offered by my colleague from Georgia. I do appreciate her earnest interest in enforcement of the privacy standards that we seek to modernize in the underlying legislation. But I oppose the amendment because, as the chairman mentioned, a federal private right of action for privacy violations has been considered and rejected both by Congress and the federal courts in the context of the Federal Trade Commission Act, the Consumer Financial Protection Act, in other words, Title 10 of the Dodd-Frank Act, and the Gramm-Leach-Bliley Act. There is a well-established canon of statutory interpretation called the presumption against implied right of action. And this canon says that a statute's mere prohibition of a certain act does not imply creation of a private right of action for its violation. The creation of such a right must be either express or clearly implied from the text of the statute. The gentlelady from Georgia obviously understands this. That's why she's offering to explicitly create a private right of action. But it also underscores why there is a bias against it. When there is a well-established occupation of the field by an extensive regulatory scheme, the presumption is you don't need a private right of action because you already have a well-established body of law that prevents the prohibited conduct. But I'd like to add some additional context for why I'm opposed to a private right of action in this context. The financial services industry is already heavily regulated when it comes to consumer financial privacy, data privacy, and for good reason. Financial data is some of the most sensitive data a consumer has, and we should all enjoy strong protections in place. But with these strong protections comes a heavy compliance burden placed on our financial institutions. That's one of the reasons we included a provision specifically directing agencies to consider compliance costs when promulgating rules under this bill, particularly for smaller institutions. Banking regulations are complex, and as we have heard, they may vary from state to state, making compliance difficult and expensive. Imposing a private right of action could expose our financial institutions to frivolous litigation that can ultimately result in bank closures, credit union closures, and could result in fintechs and other innovative lenders or service providers from exiting the market entirely, stifling the very innovation that has resulted in financial inclusion and convenience. This is not pro-consumer, this is anti-consumer. My district is comprised of community banks, credit unions, and other lenders and fintechs that have the ability to serve the specific needs of small and rural communities. Farmers, small businesses, and individuals rely on these service providers. Implementing a private right of action could lead to closure, stifle innovation, stop competition that would harm the diverse financial ecosystem that makes our country, all around this country, the communities all around this country so vibrant. And let me just conclude my arguments in opposition to the well-intended amendment with the following. Even if you do support a private right of action, I would argue that this particular amendment is not drafted a tailored way. It's overly broad. There is no right to cure in the amendment. A financial service provider would have no ability to cure as a requirement or a necessary step in order to file a lawsuit. There's also no requirement to file a complaint with particularity. Demonstrating standing in the context of privacy is difficult. You have to show a real and concrete and individualized harm as a result of privacy violations, and this can be very challenging. There's no requirement for pleading with particularity here. There's also no process in place to screen potential lawsuits to prevent those without merit from proceeding. There's no limits on damages to prevent uncapped legal exposure or inconsistent results and disparate interpretations across different judicial jurisdictions and venues. If you are going to support a private right of action, my suggestion would be we would need to reduce financially motivated lawsuits. We need lawsuits to be focused strictly on vindicating the privacy rights involved. And finally, in this draft, even if you support a private right of action, I would urge opposition to this version of it because there's no safe harbor for entities that take proactive steps or experience a breach from exceptional circumstances beyond their control. There needs to be affirmative defenses to the extent we do have a private right of action. With that, I urge my colleagues to oppose the amendment. I yield back.
Tell me